Good morning, everybody. Yeah, I almost overslept. My bad. It's been a mad dash this morning. I got here with no makeup, no hair, barely clothed. I want to give a shout out to Trial TV Live. They are amazing, and they are providing our link this morning. So if you are watching other stuff that's trial related and you're not going to watch here, go hop on over to their channel. I know a lot of the larger channels are streaming things, but I want to help them reach their 1,000 subscribers. Right now they're at 721. So I really want to help them. So they bless me, so I want to bless them. So go over and subscribe if you've not already. Good morning, Eddie. Hi, good Norman, Denise Feldman, Ursula. Good morning. Yes, I am up early. I've been getting up early lately, and I'm not happy about it. I'll be honest, I ain't happy about it. This chick is not used to the early morning sunrises. I'm a night owl. I'll stay up till 3, 4, 5 in the morning, but don't ask me to wake up at 3, 4, 5 in the morning. I'm looking for some earrings, and I don't think I have anything to wear. Nothing matches. Well, I could, if I have the match, always wear turquoise. So, no, I don't know where it is. We are waiting to see if the Florida versus Boone is going to actually play today. We don't know if we're going to actually have a court feed. Excuse me while I dig for an earring. We don't know if we're going to have a court feed. They don't know if we're going to have a court feed. So I am waiting for court feed. Oh my gosh, y'all. A friend of mine gave me these a while back, but I don't think they match what I got on today. So love you, baby girl, but I can't wear it today. Oh, honey child. Oh, that's going to go in the trash. Where are all my, y'all, I think all my good earrings, I've worn them home. No good earrings. Oh, well, I'm going to go earringless today. It is what it is. It's that kind of morning. I do have to take my meds. The
I don't know what to say about this woman. I really don't. I'm struggling. I'm struggling to be nice. And I'm trying to be nice. But this woman rubs everybody the wrong way, like sandpaper stuck in your underwear, as my grandma used to say. My grandma used to say that. I was like, oh, grandma. She goes, well, it does. Okay, grandma. Do you know what I find interesting? The older I get, the more of her sayings come out of my mouth. Have y'all ever noticed that? Y'all experienced that? The older I get, the more of those sayings start flying out of my mouth. I don't know, y'all. Oh, good morning. We are waiting for the Sarah Boone trial to or hearing to start. Um, y'all, it's early. And then this afternoon, you will have to hop on with us this afternoon because we have the Karen Reed motion that we will be viewing. So you'll have to come back. So good morning, Miss Eddie. How are you doing today, lovely? That first sip of coffee is heaven. I want to start singing. Denise, yeah. I want to ask, is that a compliment? I would say, well, thank you, darling. That is so mighty nice of you. That's how my grandma talked. It was funny. And funny, but true story. And I got a hair in my face. Funny, but true story. I was born in Bristol, Tennessee. And I know some people go, oh, don't tell people where you were born. They can find out. Chick. You want to find out where I was born, you don't need me to tell you. Anyway, I was born in the hills of the Appalachian Mountains. And I was adopted by a military couple from Texas. So by the time they adopted us at 4.5, by the time I was 5.5, I had the worst accent. I had the Tennessee accent with the East Texas drawl. I was so mixed up, you couldn't understand what I was saying. And my poor mama and daddy had to put me in speech therapy because they couldn't understand me. Oh my gosh, I remember those days. My children were exactly 4 years, 4 months, and 4 days apart. So my son's first day in college was my daughter's first day in high school. And oh my gosh, I remember those days. How you doing, mama? Are you crying for joy or are you sad? Now you got two in high school. I don't know how many kids you have, but I hope they're in the same activities. Otherwise, you're going to be one busy woman being split between the two. Sometimes it's a compliment. Sometimes I get an eye roll. Well, at least you get a compliment here and there. Mm. Well, I'm going to fish around and see if there's anybody else talking about this trial. They said if it is not on live, that they would get a recording for us, which is awesome. Trial TV live is awesome. Love them. No, that they don't have it. We looking for it, y'all. We looking. Give me a minute. Let me get some sound playing here. We are I gotta be honest with you. I'm like, yeah, I can do that, but that's too much. There. We will do happy birthdays in a hot minute. I forgot to do them yesterday. I apologize. My bad, y'all. I do apologize. I do apologize. Does not look like they have a Miss Boone beat up on court TV. Okay, let's look at long frame. Y'all, I don't know what's going on with people, but I'm scrolling down through the trials that are on right now. And, oh, good morning, C. Morales. And there is too many trials involving children. It really is disgusting. It's disgusting. Very difficult. Are you kidding me? Mom of a bride accused of trying to upstage her daughter in her wedding. The daughter's wedding. In social media is gone bat crap crazy. I'm like, are you kidding? Y'all. Sorry for the honors. Y'all know me. Too many of these kids' cases, it's getting to bother me. We are awaiting the video for the Sarah Boone. The stroller is, oh, thank you. Thank you, Trial Live. Not sure if the court will allow live streaming of this morning. If they do not, we will upload it later when it's released to the public. So we're waiting. I'm going to wait a little bit just in case. Maybe we can watch something else. Everybody, good morning, good morning, good morning. Good morning to you. They haven't been at the same school for 7 years. They are happy. My daughter's favorite teacher is filling in for one of my son's teachers this week. Oh, that's cute. That is cute. Oh my gosh, y'all. That's sweet. I remember the jump from elementary to 6th grade was a huge jump. Huge jump. Massively huge. Oh. Since she put this on Facebook, I'm going to share this. For those of you who know, my sister is battling a terminal cancer. Her name is Tracy, and I spilled coffee on me. And she pops on here. And on Facebook, she posted this little thing from an unknown author. Okay, that's my last one. I may not be your first love or first kiss, first sight, first date, but I just want to be your last everything. And she writes, we are not each other's first, but we will definitely be each other's last. Please lift my wonderful husband up in prayer. He worked so hard, and then on top of it, he takes care of me. This has not been an easy year for us. but you would never know it by the way this man works, and I can amen that. This man loves me like Christ loves the church. That's definitely an amen. And there isn't anyone I'd want next to me during this time. Thank you, my love, Doug Guard. You complete me. Y'all, pray for them. He is definitely running the gauntlet right now. And he's such an amazing man. He is a wonderful example of a good, godly husband. He really is. He's amazing. And it's been a hard road for everybody, but she's doing good. She's doing good, all considering. She's doing really good. But let's see, I need to get to the birthdays. Forgive me, I got distracted. My bad, y'all. Let's get to the birthdays. We got a lot of them, I think. Got them up. We gonna go to the happy birthday song. I don't think I changed it. Okay, let's go.
Happy birthday to you. Happy birthday to you. Happy birthday. Happy birthday. Happy birthday to you.
Happy birthday, Miss Allison. Becca, happy birthday. Eddie, may it be a blessed birthday. Brenda, have a great day, love. Beckline, happy birthday. Dawn, happy birthday. And for those of you who know Dawn, please donate to her rescue. It's for the Texas Cattle Dog Rescue. Monty Roebuck, oh my blessed happy birthday, beloved. Nicole, happy birthday. And Emily Robinson, happy birthday to all of y'all. I hope it's a good day and a great weekend. Happy Friday. Oh my gosh, happy Friday. Happy Friday. Alrighty, beautiful words praying for your sister, family, and you. Oh, thank you. It's not easy. Yeah. Thought about her and I doing a live together, but her energy, she's good, but her energy is just too low. Well, it doesn't look like we're going to get coverage today, y'all. Let me go back and do some shopping and see what we can find up with. I'm so sick of seeing Martha Stewart. I could care less. Well, I'm so bad, y'all. I apologize. It's just every time I open up my feed, there's Martha Stewart. I'm like, why? I don't ever click on it. I don't understand. It just, I don't know. Yeah, I know, babe. It's okay. Trial Live, it's okay. Um, Trial Live, Trial TV Live. Are you guys members on my Discord? Because I really wanted to ask you a question or two. And, well, and I need to find my mods are here, but I don't think I have my Discord. I don't have a Discord link available to me. Eddie, do you have our Discord link? Can you throw that up for me? If y'all are not a part of our Discord, it's a good group, fun group. I don't overwhelm people with stuff, but I communicate with you. Well, We've got other people waiting. Oh, that'll be fine, Miss Eddy. Thank you so much. So why don't we do this? We're going to go through Miss Boone's motion. Let me get it up. Her letter. I started to do this yesterday, y'all, but I was so not feeling it. Have you had a day like that? I'm none of your bites. Hi, good morning, love. Well, we are going to go through the Sarah Boone motion that I didn't read through yesterday. I was just not feeling it. Um, I felt bad. I just didn't feel good yesterday, honestly. I just didn't feel good. And so we had to, hey, Miss Jules, you want to hop on with me? You're welcome to. Just let me know. I'll pop up the link. I will pop you the link if you want to hop on with me, beloved. This is where we're going. Hey, hey, hey. Good morning. Good morning. And I am wide awake. Barely. I'm barely awake, y'all. Oh, I'm so sorry, love. Well, I won't throw you the link. If you want, just let me know. I'll throw you the link. Just say yes. If not, just hang out and type text. That'll be great. Maybe later. Oh, I'd love for you for Karen Reed trial. Definitely. Okay. Yesterday we were trying to read this, and um, I have to admit, with dyslexia, it is very difficult to read this kind of writing for me. Yep, saltwater works for a lot of us. So I'm in a better place. So let's see if we can get through this. I just have a problem with her rhetoric and crap. So we'll see. This is a motion for the defendant to lawfully receive, review, utilize, organize original hard copy discovery, 2 boxes, A and B, submitted to the court by formal attorneys on June 28th of 24 for the preparation of trial in her criminal case. Comes now Sarah Boone, pro se indigent defendant. Are you kidding me? Why do you have to constantly say this is beyond my understanding?
Pro se, indigent, defendant.
Respectfully request from the court to lawfully receive, review, utilize original hard copies, discovery, 2 boxes A and B, submitted to the courts by formal attorneys on June 28th, 24, preparation of trial in her criminal case. So you said that twice. Whoa, whoa, wah, 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 wah. Wah, wah, wah. Discovery definition. Okay. She has the same problem that Morrissey had. We do not start a new paragraph on the second to last line of a page. You started at the top of the next page, woman, please. Discovery definition. What was that? Did y'all hear that? Well, there's no one in here. I've got the camera on. Must have been the cat. The process through which attorneys acquire evidence in an exploration or examination, finding something out by search observation. Smart commune tablet discovery. Yeah, too many definitions. I think she's got too many people, too many what we call jail lawyers, whatever there's a term, I can't think of it. Criminal lawyers, I guess. I know that's not it. But anyway, people behind bars pretending to be lawyers helping her. And a book called The Law Library. B, the process through which attorneys acquire evidence in the case of the encompass particularly everything, practically everything an attorney may or need do under the rules of criminal procedure to acquire evidence before trial can be categorized such as documentary, testimonial, or physical. Law Dictionary 2012. Uh-huh. She's found the law library, y'all, without a computer. Filed and processed box. Okay. Filed and posted on the Clerk of Coroner's website. Judge on July 9th, 24, 9:31, and evidence controlled sheet states. I don't know what my cat is doing, but she's loud. I haven't had a cigarette since May, and I'm still struggling. I know. None your business. I get it. She's way in over her head. A box of discovery. B box of discovery. The court will reach out to the jail to inquire how to deliver, said, I want to be sarcastic, but I won't, to the defendant and will provide written order to release both boxes. How can anyone say this handwriting is easy to read? To me, it's not. It's hell. Give me pure cursive. Half writing, half cursive doesn't work for me. These two boxes, A and B, are the defendant's original discovery. She has not seen in full to present something, and it is her right to receive by law to fairly proceed in her trial defense. Oh my God. Oh my gosh. Are you kidding? Statute B1 shall disclose the defendant and permit to inspect copies and photographs of the following information. F, any tangible papers or objects that were obtained or belong to the defendant. Well, G is missing. H, sanctions. I, if any time during the course of its proceedings it is brought to the attention of the court higher that a party has failed to comply with the applicable discovery rules with an order issued pursuant to the applicable discovery rules, the court higher may order the party court to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a retrial, or something. I want to say endure, but I can't. Such other orders as it deems just under the circumstances. Oh my gosh, I already got a headache. This woman is driving me back crazy.
Your Honor, please, allow her to type this crap out and print it. It's killing me.
Willful violation of counsel or party not represented by the counsel court of an applicable discovery rule or an order issue. Hey, Megan. Pursuant thereof shall subject counselor the unrepresented party court to appropriate sanctions by the court higher. The sanctions nearly include but are not identified to concept proceedings against the attorney or unrepresented party court, as well as the addressment of the court's defendant time to prepare, incurred by the opposing party when appropriate. Oh my gosh, y'all. Oh my gosh. This, y'all. Yeah. WTF is right. The signature of the attorney or party court constitutes a certification that the signer has read the request, response, or obligation, and that to the best of the signer's knowledge, information, or belief form after a reasonable inquiry is ... Oh my gosh. How many more pages? The government is obliged under Brady and United States versus whatever to disclose. What am I getting? Sorry. Information in its sole permission that is material to the issue of goal or I can't understand. Oh my God. The government places heavy reliance on the case that holds information is material if there is reasonable probability that had the evidence discovery been disclosed to the defendant, I'm having to use my pointer, I'm sorry. Result of the proceedings would have been different. Any document. See, she runs her words together here. That's part of my problem. There's not much separation. Nunya. She starts writing nicer after seeing them on TV. Then they used to be written as if in a hurry. Yeah. Well, and they're running the words like when I look at the monitor where the camera is and what y'all are seeing, everything runs together. Everything runs together. And that's my problem. Any documents or requests made initially unavailable to the defendant through discovery and the federal rules of criminal procedure are in direct violation of the defendant's due process with prejudice and shall not be denied. I guess that's restricted or deferred upon request by the defendant. By doing so, this contributes international misconduct warranting sanctions. Hi, Karen. Hi, Braxton. Hey, I was married to a person whose handwriting was so bad it was voted the worst handwriting in the college history. I kid you not. This is difficult. Braxton, did you survive last night? And are you working today? They just look neater to me, not nicer. Content wasn't really clear before. Good morning, Braxton. By the court only providing digital USB discovery to be reviewed solely on the laptop provided by the OCCD and restricted to select times during the day. Motion for extended times in process. Oh, God, another motion. Without the necessary hard copies, the defendant is unable to A. Review, research, investigate, build her defense at any time. Nonetheless, the hours are in nevertheless, hours are ineffectual and wasted by not having access to the laptop and by not having the original hard copies available to physically to use physically during the laptop's closed hours. Um, Woman, let me explain something to you. You're in freaking jail. Where is that? That's not my music. Thank you. Love the music, however, 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 okay, sorry. I am just making sure we have a good coverage just in case it hops on. Um, One thing I don't understand, well, she's not convicted, so there is a difference. There is a difference between convicted and not convicted. So, I guess I kinda have to be a little more, um, non-judgmental because she has a right to a fair trial and she's not convicted. So, there goes that. Okay. B, write notes, remarks, interpretations, explanations, and make recordings of any kind. Transport to meetings in any location, including the courthouse. Make copies for distribution or, if necessary, presentations in court. Okay, I agree with that phase, but all she has to do is mark it on the email it to the court. I need copies. I haven't noticed the word fair in this correspondence. That's a good comment. If one form of the defendant's discovery is unavailable, the others should be available without interception for unrestricted full access to equally at all times be able to lawfully prepare for her trial. Okay, I understand lawyers work around the clock. I get it. I get it. But you're the one who screwed the pooch. One attorney wasn't her fault. A couple attorneys didn't like her. She didn't like 99.999% of them. So she created this debacle. So she herself now is upset with the position she's in and trying to use the courts to her benefit. No bueno. No bueno. Not at all. No bueno. Both are available to be provided by the courts. Due to the court's error of not communicating with defendant foremost to avoid present circumstances and the jail prior to the implementation of the order on June 28, 24, and after the defendant's July 8, 2024 letter requesting location of her promised hard copy discovery 2 boxes A and B as directed as a result of her extended writing period for delivery or extended waiting period for delivery by the court to expeditiously review, research, organize all contents, and attempt to prepare all pretrial motions as ordered by July 22nd, 24. The defendant is now forced to I can't read that. If y'all know what that word is, tell me. Yes, she does at 1 o'clock, I think Central. If not, it'll be 12 Central. By the court USB copies of her discovery. It is an obstruction, It's an obstruction of justice to withhold the defendant's original hard copy discoveries that has been compiled for ongoing 5 years to properly, fairly, physically. There's fairly. Ding, 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 ding. We have fairly, physically construct her rightful defense at all available times necessary to her and on the sole independent decision of the court, the defendant. Okay, is she being housed in a single cell or is she in a big open area? Yeah, that's 7:45 my time, and it didn't. If not asked for, did not ask for, wait, yeah. 1, did not ask for or suggest this USB only option. 2, was not included in any decision-making collaboration or equal agreement for USB only format to be received. 3, was never advised by the court prior to the implementation of only receiving USB copies. The defendant was excluded and avoided in this incredibly restrictive decision. Yeah, and I think that's part of the problem. If she's in an open area cell, she can't be up at 2, 3 in the morning because everybody else has to be down. And that was my understanding. Now, if she was in solitary confinement, another story. So, my option to her would be solitary confinement, where you're in there 23 hours a day, only out 1 hour today for exercise and shower. So, if you want that kind of access and have the laptop with you and all that kind of goods and have the boxes in with you, then go to a solitary confinement. Sarah Boone is housed in a location Winter Park cell. Okay, you're so awesome, Rita. So I can understand why they do not want her up at 2 a.m. and having these boxes because there's no way to secure them in that. They do have a little locker. There's no secure place for these, and I can just see her getting these and having them back there with her, and then saying, oh my gosh, mistrials. They made me do this in the jail. I had all my boxes of stuff and all my evidence, and it all went because people stole it. I can't defend myself. I have to have a mistrial. I bet she runs that sale block. She's probably top dog. Man, top dog is a big deal in the sale block. If you haven't watched Orange is the New Black, watch it. Yeah, maybe not. It's got a lot of X in it. Time, consideration, and inclusion should and could and should have been made in the court's on the court's behalf to can't avoid present discoverage circumstances, and the defendant would not be deprived of her due process and equal opportunities to correctly, fairly, ding, 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 represent herself and succeed frivolously. Hi, In and Out with Diane. Good morning to you. Yes, a lot of prisons do have those kind of libraries, but the problem is securing all these documents. And is it putting an unnecessary burden on the guards and the staff to maintain? Wentworth. Well, but they had jail cells with 1 or 2 people in them. Here she's in like a big gym with cute, bunk beds stacked all over. Yeah. Or a big room with a bunch of people in it. So it's not secure. So if she's has these boxes and she is not with him 24/7, I can very easily see these inmates going over there and stealing some good reading material. Oh, no, you got that right. But do you know what? Even the most hardened ones can curve to someone like this one. Wherefore, Sarah Boone. Oh, no. Here you
Go again. Sarah Boone, pro se, indigent, defendant.
respectfully request to this honorable court in conclusion to lawfully review, utilize the original hard copy discovered 2 boxes A and B submitted to the court by the formal attorneys on June 28, 24 for the preparation of trial in her criminal case. By receiving the original hard copy discovery, 2 boxes A and B, in addition to the USB digital copies, the defendant is capable of reviewing discovery information available in continuous preparation of her trial, enhancing her ability to thrive lawfully in her.
You ready? Force by the court, possession of pro se, and representing oneself.
Excuse me, I got an itch. Inmates are allowed to use tablets for legal research in the area where Boone has been housed, I believe. Yeah, but it doesn't have the download of all her information and doesn't have enough space for that download. Instead, a laptop that has been cleaned and proved and has monitoring program on it to ensure that she doesn't do anything she's not supposed to do, and will be kept under lock and key with a very secured password, only known to her and probably 1 or 2 other people. Can't believe I said that. Oh, the oath. Oh, we got to do it. Got to do it.
Under the authority of Section 92525 Florida State Statute and State versus Shearer 628 SO2D, 1102, parentheses FL.1994, the defendant makes the following oath under the penalties of perjury. I declare under penalty of perjury that I have read the foregoing document and the facts and matters stated are true. I, undersigned, dumbass.
Okay. And I'm not going to read the certified of services. Oh, y'all. Oh. Well, they're playing something, so let's go see what it is. We scrub through it. I just saw it. Okay, we're going to put this on pause, turn the volume up, get it on screen. We have something. I don't know what it is. We'll see together. Together, wherever we go, through thick and through thin, oh, Lord Orlean. Oh, this woman's cray cray. Can't stand her. Anyway, you didn't hear that. Play. Volume. Where's the volume? No volume. Play. Come on. Her story. Told investigators they were drinking and playing hide and seek. Called the police hours after Torrance's passing. Why are we not?
2024. Have you received both of those?
I did, and I had.
There's a copy.
Okay, guys, I may have to gang this up.
Investigator and the scheduling order. 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery. And that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to PO Box 9101.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order, where you were representing yourself pro se. So that is incorrect.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can tell you that other
Ooh,
than
the
July
judge is
29th,
not on it today.
The next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come.
Wait. Wasn't it ordered? I have a copy of it. I thought it was ordered she could be there without handcuffs on. Huh? Why are handcuffs still on? And yes, she obviously has a tablet.
Come on up, sir, so Madam Clerk can swear you in.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Billy Lane, Chief Investigator, owner of Prison Break Investigations.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So either Mr. J or Mr. Cacciatore.
Yes, Your Honor. We have tendered to Mr. Lane a copy of our the exhibit list with our expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness list, also proposed jury instructions and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question. Okay.
And I have a copy for defense.
Okay, very good. Deputy Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
In your honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list, and then the notice of expected evidence and witnesses in trial. I don't have an order for.
There wouldn't be an order, it would just be that first document you read, reference to notice of provision of witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are.
Okay, that's for this morning.
On the USB drive that are digital in nature. Is that correct?
Yes.
This is the best thing.
And those are
I have gained it up almost
the
100%.
USB drive that is going to be provided to Ms. Boone.
Are y'all hearing
They're
okay?
broken down by folders.
And the folders, are the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that
And drill.
on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to Suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well, as Mr. Lane has had an opportunity to copy for his client that I can tender to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing?
I
guess
can't.
not, since it's going to be transferred to.
I'll gain it 100%, but then that's all I can
Okay,
do.
all right. You can go ahead and give that to Mr. Lane. All right.
Thanks, Libby.
Ma'am, or Mr. Castori, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay.
Yeah, we're
Have
not.
you had the opportunity to review the notice of expected evidence and witnesses and trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay. Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you mean you cannot open a majority? What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats. But there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't know.
What does it say?
I don't know. I moved on from that to try to go to other programs. So
Okay, woman. You document your toilet paper usage by the centimeter. And you're telling us that you didn't write down the error message? I call bullshit.
I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now, that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. And that's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount when I.
Okay, on my other stream, someone wanted to know why I'm covering the suitcase. I don't like that picture. I don't think they should be using it. It's an evidence picture, number one. Number two, there's a body in that bag right there, right now. That picture is not an empty suitcase. There's a body in that suitcase. And I don't think it's right for them to be showing it so loosely. I just, it's not in good taste.
Click on a
So I'm
particular
covering it.
file. There's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The one time
One
that I,
file, 10 files, 20 files, 50 files, or was it just the one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what
to.
for the most part means.
I haven't had time yet to explore everything due to the dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you. So you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
All right. Dave?
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find the VLC files for where the Publix video has been converted. So everything in there should be standard JPEG, VLC, and also believe an MP4 or some audio only files.
All right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
That was what was just handed to Mr. Lane. So Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure. Okay. State anything.
All right, we're gonna get in a break. We'll hit the pause button on what's happening inside.
Y'all, out and about with Diane, should they not put her in a space on her own with the files? They will do that from 8 in the morning until 4 in the afternoon. But they cannot hire people to sit with her at 2 o'clock in the morning. Unreal.
Inside of that courtroom. Remember, she's also
What? You're kidding me. No. Are you kidding me? Are you kidding me? That's not cool. Debbie, not cool. Definitely not cool. What happened? Really? That's it? Good point, Jewel. Jules is over on Court TV. Jules is over on Court TV. Love you, Jules. Um, she was provided with Judge EJA's email address, so there is no need for her to handwrite these motions. She can type them out and file them. It's neat, and the court receives them quicker. Good point. Good point, Miss Jules. Although she can't hear me saying it. I don't know if they're on a break. Right. So what they're doing, I think, are their commercials and whatnot. So they're on a break. We'll be back.
Anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay, all right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her if you don't?
You're
Okay, all
welcome.
right.
Over.
I have had the opportunity to have further conversations with Major Mohammed at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property in the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Miss Hall's first name?
I don't know any of the officers.
Okay, all right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time, and that to whom you gave it should be Major Muhammad, those items, so we can file in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously. And Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this. State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No.
Okay, so for the record, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case.
So there you go. The baby can stop crying now.
As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman? Okay,
We're
were
gonna hit
they-
the pause button.
If she gets the hard copies, why does she need the computer? Well, she does need to type
As
her
we are
findings.
about to reach the top of the hour, small win there inside of the courtroom for
Okay, another break. That is a small win for her. See, I don't ever have a problem with her having the hard copies. It's just, if I was the jail, I would say, if I was the warden, I'd say, look, we will have to move you to a single cell, and you may have to have some modifications, and you may not be happy with all of them, but I would make her sign an agreement that they are not responsible. The court, if I was a judge, I'd say, you cannot hold the court or the prison responsible for any or all of this paper evidence should it disappear. Because inmates love stealing paper and reading. They will. It's entertainment. And it's juicy stuff. So my concern is the liability should any of it disappear. She goes to the shower, comes back, bye-bye. They are. Yep. Exactly. Inmates love stealing court documents. Say you have a file with all your court stuff in it, and you're in a big open area like that, it is not hard for them to sneak over there and start grabbing just stacks of things. And it is more secure on a digital format. That's why I'm saying that if I was the judge, I would make it very clear that she is accepting all responsibility. The court nor the jail are responsible if these disappear, and it's not going to delay trial. You are doing this at your own risk. End of discussion. I don't like protein bars or whatever they're called, grain bars, but this is pretty decent. I'm hungry and I don't have anything else to eat, and this is one of my daughters. I can tolerate this. So Runkle is definitely right on that, but he's not wrong on anything. I hope to be interpreting them tonight. Hopefully. It's been 2 weeks. They've not had it on. Jordan Child's coach, gymnast, pushes back against allegations she cheated to win the bronze. Well, people are going nuts over this. The gymnast was in 6th place, and see, they score the like the floor routine based on the difficulty of it, and her coach, after seeing the scores, felt that her baseline scores were too low for the difficulty of the actual routine, which that can happen. So she petitioned for an audit. And that's perfectly legal within the Olympic rights and the rules of gymnastics. And after she did her routine and everybody did theirs, they audited it and they felt that her routine was not scored appropriately. It was the difficulty score on it was too low. So they revised the difficulty score, and then she got 3rd place. And everybody's, oh, she was 5th? I thought they said 6th. She ended up 3rd. And a lot of people in the Romanian, I think it's the Romanian, if I'm wrong, Miss Colleen, The Romanian national delegate or whatever is refusing to go to the closing ceremonies and boycott. Of course, it was his gymnast that got bumped. This is from HEB, our grocery store. It's the Originals Organics bar. Not bad. It doesn't taste like cardboard, at least. Yeah, I know. I'm bad. Texas, oh my God. Texas leads most countries in Olympic medal counts. Texas is kicking butt at the Olympics this year. Mm. Judge orders My Pillow mogul Mike Lindell to pay attorney fees to winner of the Prove Mike Wrong lawsuit. When you are selling something and you say, prove me wrong or I'll pay, that is not a wise comment. Travis Scott arrested in Paris after a hotel fight with his bodyguard. Don't even know who he is. Happy for Jordan, but got a feel for that girl. Yeah.
Matter this morning is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed with the court on August 5, 2024. Courts have the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay, so ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions or cross-examine him after the state's concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay,
Do you have any questions about that process?
I don't.
Okay, all right, let's go ahead and call your witness. State.
Anything that says mystery when it comes to flavors, this chick won't try. By the way, I had someone comment on it, and I think, first of all, people, learning moment. I understand we, as human beings, get pimples. Some of us get cold sores. We may burn ourselves with a curling iron. And some of us have a food allergy to citrus. Deadly if ingested, i.e. lemons, limes, oranges, grapefruit. If you want to kill me, give me raw citrus. Okay? I'm not exaggerating. This little thing here on my nose, it's not a cold sore. If you are sitting across from me at dinner and you squeeze a lemon and just the faintest of mist of lemon hits my skin, it looks like a cold sore. It's not a cold sore. It's a reaction to citrus. Somebody basically said, "Hi, Leah." Made a comment about me trying some holistic medicine for it. Y'all, if you ever see me with one of these that's really huge anywhere on my face or on my hands or in my person, on my person, just take it as it is. It's a reaction to citrus. Okay? So cat works great for my cat allergies. It's not that kind of allergy. It's an EpiPen if digested. If it gets in my mouth and I swallow it, it's an EpiPen, and I have an EpiPen everywhere. I have them at all of my friends' houses that I visit. I have it in the car. I have it in my purse. I have it in this room. I have it in my other office. I have them all over the place. Yes, I'll be covering Karen Reed today at 12:45. So please understand, y'all. I, I, I don't understand why, and I'm not disciplining anybody, and I'm not being rude, but y'all, please, it's embarrassing enough to have to come live with this, much less have a coffee date with someone I've never met before on Sunday and have this. But it is what it is. I am highly and deadly allergic to citrus. Okay, moving forward.
Please swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, LLWTA.
All right, thank you. State, you may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area of the sheriff's office are you assigned?
Court security.
And how long have you worked that assignment?
4 or 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge.
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, to me, it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Logan?
I do.
Go ahead.
First off, in your inputs research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued. I've never hesitated.
Object to the form of the question, Your Honor.
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
Okay.
I am prepared to give her the date. On September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you're scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At the
court?
jail, yes.
Who is your contact, please? I've never missed a date.
This is the database that I got this information from.
Do you know when it was last updated?
I don't know.
Okay, so do you know how, I have never missed a court date to the present date. I don't know specifically what these 3 dates are for. In order for me to have supposedly denied going. Do you know the name of the officers for each one? You do? Please.
For September 15, 2023, it is Corrections Officer Portia Hines,
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
And if you would like, I can read her comments in her report.
Sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically what your hearing is for.
Okay.
The second one, it'll be Officer Christy Green.
And what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K.
Greene.
Yes.
10/16/23.
Yes.
Okay.
And the third one is January 28, 2021. And the officer is Jasmine.
I want to hear it.
SCRIBNER.
What are the comments, please, for Green?
Approximately 300 hours, I advised inmate Boone,
True.
Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward of the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay. And January 28th?
At approximately 03:34 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information down.
Okay, so I'm trying to figure out how I know all 3 corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
I'm going to object this to ask and answer.
I'm going to sustain the objection.
So the domestic violence, the original was dropped. I was never charged with that.
Object is to relevance, Your Honor.
Overruled. You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate. So they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
It's Your Honor, I'm going to object to the question.
Objection sustained.
She ain't gonna like that.
Those the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to object this to the form of the question. It's not a question, it's a statement.
Sustained.
Forgive me because I don't know what I'm doing.
Who
I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently. So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that isn't your history.
I understand, but I was never charged with it, correct?
You were charged.
We are hitting the pause button on this pretrial hearing, and we're going to bring in trial attorney Krista Ramey.
You know what?
Krista, thanks so much for joining us this morning. We thought that this motion to be unshackled would be pretty easy of a win for Sarah Boone. She's going to be in front of a jury. Perhaps we thought that it would be easy for the security officers to still manage her even if she's not shackled.
Okay, so we're going to another commercial break, and with that, I'm going to run my own. You guys, we have a fabulous sponsor, and I absolutely love them, and I'd like to share them with you right now. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Kirk option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. Oh my God, y'all. We did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members-only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon-to-come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing. We back, y'all. Our interpreter will be with us today, this afternoon, when we go live for the Karen Reed trial. She had another job this morning, which is good. Paid jobs come before volunteer anytime. Please, guys, join our memberships. We are working on providing a bunch of different things to different levels. None your business. Woohoo! I am looking at doing I don't know how to do it. I got to figure it out because I mean, you got to have StreamYard to pop into StreamYard. So I'll figure it out, but I want to have a live, kind of like a Zoom call with my top members. Then we have our members only live that starts off at the $4.99 level, which is called Judge. We have alternate juror, judge. No, alternate juror. No, juror. It starts at juror. Sorry. Alternate juror, juror, judge, supreme judge. Really, Colleen? How is that? What phone do you have? An iPhone? I have an iPhone. I can help you there. If you don't have an iPhone, somebody else will help you. Yes, we are getting a sneak peek on how this trial is going to function. iPhone 14, yes, it will. Let me get to it. I'll walk you through it. I got to go through it on mine to walk you through it. Okay, I'm going to go to my YouTube channel. Give me a second. I'm going to go in like you do. I got to get to me. Open me up. Go to my lives. I'm going to click on that. Okay. So what you're going to do is click on the live. You are. So what you're going to do you see a little dollar bill sign? I'll use my pointer. Let me get it right. You see that little dollar bill sign? Let's click on that. Super chats only? Why? That sucks. Wow, okay. Me bad. Wonder if I apologize, love. Do you guys have so you don't have a computer? If you go on a computer, you can join. You can join if you go on the computer. This is frustrating. I didn't know that. Darn. Is it one of those things you have to have so many members? If it works for some channels, how many members do those channels have? I haven't even had, honestly, guys, I haven't been monetized a month yet. It's only been 3 weeks. I think it's been 3 weeks. Is that how many weeks it's been? I haven't been monetized long. So with that, we have 30 members. I am so excited, but I'm equally excited to have non-members. You are all welcome here. Oh, that is so funny. But didn't she say she excels at everything? Oh, that's funny. That's good. That's real good. Let's see if we can bump up.
No. You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
Whoa, let's go back.
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
She was
The
charged
rest is
with
on your record.
violence.
But the charge for the domestic violence is not on my record.
No, you were never.
Asked and answered, overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
For the
What?
three,
See, what she's doing is playing games. If you have a deferred adjudication, that means that you are agreeing to plead guilty for the time being, or no contest for the time being. If you meet your conditions of probation at said time, at the end of that probation, the charges are dropped or dismissed. Playing with words.
Supposed non-compliance that I have. I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it a?
Your Honor, I'm going to object to the form of the question. This is a statement, not a question.
Objection is sustained.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to, that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
What do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question. Overruled.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's up?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not.
Just to clarify, sorry guys, just to clarify, it's a part of your history. It is a part of your record. It's not being used against you criminally, but it can be used as a pattern of behavior. You can't win everything, my dear. And when she is in front of the jury, she will not be handcuffed, but she can and very most likely will be shackled. But she doesn't understand. Deferred adjudication does not get used against you. But when you are in a new trial and you're sitting where you're sitting, it is a part of your character behavior. They don't expunge things anymore. That's a misconception. And that's where I struggle with people, because they think that just because it's suppressed or expunged, it's not ever viewable. For example, if you live in a state that has a lead shooter license and you have trying to think of something. Say you were charged with lying to a police officer. Very small misdemeanor. And you deferred adjudicate that. Then, when that's completed, it is supposed to be removed from record. It won't be. You have to go and petition the court to remove it from the record. That doesn't mean it's not still in the bios of the record, but it also means it can't be used against you. But the fact that you were charged and all of that is still available to certain agencies, i.e. any licensure agency, any police department agency. It will not show up on a basic background check. But if you're going for a licensure, like with a lead shooter, they will see it, but they can't use it against you so long as it has been suppressed. Oh, yeah, Jules, I agree with you.
Ever charged with
So that's what that means.
Again, I'm going to object as to ask the answer.
Sustained.
So it's
Okay,
there.
I will, do I
Let me
provide this
see your
information
voice.
to you?
You can provide it to the state.
Oh, forgot to tell you. Difference between suppression and expunged does not mean it's gone forever, never to be seen again. If you are arrested, it will pop up. But if you go to get a job, say at a school district, and they do a background check, it won't show. And even if it did, it would show expunged or suppressed, depending on what state you're in.
Am I, in your opinion, a
Exactly.
flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be restrained.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018,
Correct.
and it is now 2024.
Yes, my dear, you can do the math.
Okay,
Oh,
and you're going solely off of what, the arrest affidavit? What is it that you're using to conclude due to this occurrence that was dropped that I would not be able to be unrestrained?
Correct. Your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons.
what? I didn't know this. By strangulation? Girl, you sick
That's why
woman.
I've said that I do not believe it's appropriate.
Now that can't come up in trial because it
But it was never proven, correct, because it was dropped?
It was dropped, doesn't mean it didn't happen.
Okay,
there you go.
I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates, the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is. So,
And you can still apply it even though it's not been,
correct. It's in your history.
okay. Thank you for the information.
You're welcome.
Any follow-ups, Dave?
No, Your Honor, it's fine.
Thank you, sir. Anything else, Dave?
Not from the state.
Okay. I see Deputy Barnett here. Did you come up, sir?
Miss Jules, we saw you over there in Fort TV.
It looks like the judge wants to address some things with his clerk and another witness on the stand. We'll hit the pause button and get you back into.
Stun cuff is a electronic.
Not your date of birth, sorry. Could you spell your name for the record?
ADBARNETT.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm the deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security
Lonnie,
measures?
can we see if we can find
other
information on
challenges
this?
that may be provided for
Here, Lonnie.
defendants?
Yes, we have an item called a stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's
Thumb cuff.
It's
Goes around the thumb.
to the leg. It has 50,000 volts and it's able to be remotely
Oh, wrong one.
sparked from a distance.
Let's go back.
How is it fixed or placed on a person? cuff is addressed with regard to other security measures other than shackles that may be provided for defendants.
Yes, we have an item called stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun
Stun
cuff
cuff,
is
oh.
an electronic device that's wireless. It's a box secured to the leg. It has 50,000 volts and it's able to be remotely sparked from a distance.
So Boone and Torres were arrested for domestic violence, both were charged with battery.
Either leg, it can be hit in the pants and gives the ability to be moved on the ground.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
Okay, Torres is arrested for battery after domestic violence incident with
The
Boone.
officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There's a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level.
Boone called 911 alleging Torres had took her credit card. Here, I'll move my
It's a 2-step process, so there is no way for an accident to be set off. It has to be hit 2 separate buttons for accidents. If it had to be used, it would cause a shock to the location on the path, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation after that.
Are there any other protocols or standard operating procedures regarding the use of the stun belt? Other than what you've already identified?
Just to follow response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment is at a level 3.
And what is a level 3?
3 would be failure to follow directions and stuff like that. If we ask her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, sure.
Ma'am, do you have any questions for Deputy Barnett?
Oh, here we go.
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of the leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts. You can take it off as court every time we exit the court. It takes a few moments besides signing the waiver and securing your ticket.
And it's a one-time waiver?
Each day you have to sign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply
Yes.
and remove?
Yes.
Thank you.
Any follow-up?
Nothing to say.
Sorry. Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. Stun cuff, same thing.
And then I would be able to walk?
You would be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up, State?
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
All right, thank you, sir. State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court?
He's going to give it the clock. I want to say
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option. Reasonable measures.
Yes.
Okay. Do I need to supply the
Oh.
information in regards to the supposed?
Y'all, she was charged with domestic battery 3 times in 19, not just 18. That's 4 charges of domestic
Non-compliance
battery on her.
that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
All alcohol.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
And thank you for that clarification, because when I read your motion, you asked to be
Okay, I want to see the skin coming off the wrist. Show me. At least they're pink.
unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me, just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help. It's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. But you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I review your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and handcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I just read. So if you would like to clarify for me now at this time, you can, as to what it is that you're asking.
Yes, handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. The first
Go ahead.
is just handcuffs means unhandcuffed. And if for trial I have to be shackled to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all on the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So again, that was why I was trying to be transparent and forward by doing so now to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
Duh.
We're hitting the pause button on this testimony. We do have to get to a break. Let's break.
Y'all, this woman, duh. Oh my God, y'all, this is really starting to irritate me. What are you doing? What do you got? Get out. Come on. Take it and go. 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 Leave it. Leave it. Go. I know. Go. Go. Oh my gosh, y'all. Sorry about that. Oh my gosh, y'all. This cat is absolutely hysterically funny. She loves two things: hair ties, Q-tips. That's right. They can't. They cannot have any of that. I'm going to have to make a phone call when they hop back on. I'm sorry, guys. I hate to say that to you, but I am. Oh, I am so frustrated. My college funding. One day it shows this, one day it shows that, one day it shows all this, one day it shows nothing. So anyway. So with that, I just love this. All right. We are, the bailiff can't handle anything. He can't handle paperwork. He can't carry it for her. They'll have to assign somebody to help her with that. He has been very, very detailed with her. I meant to say because the bailiff handled those things for Brooks. We have to be very careful with her. Boy, people sit there and kind of claim DV, but after what we're hearing here, she was the one committing DV. Now, he did hit her in the leg with a knife, trying to keep from certain words. They allowed it for Brooks. Oh, okay. Well, they may have somebody specifically assigned to do that, but they have to plan this very strategically. This is going to be a very the jail is going to have to handle all this. It does vary by state. You're correct, but they are going to have more than just the standard number of deputies there, because they're going to have to assign certain deputies, because if something should happen, they need X number of deputies to handle her, not just her stuff. Now, if something happens, her stuff can just sit there. But, wow. She is conniving. She's sharp. Some of the questions, it's like is she playing the dumb blonde? And I hate to say that because I was a blonde, but Brooks couldn't move any farther than his table. Yeah. I get this. She may have an IQ, but she kind of talks in circles like she's trying to not be smart. Come out and say it.
Would you also be asking the
Yes,
court to
yes.
move around the courtroom when trial would take place?
I'm going to keep this going.
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial.
Okay.
Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Okay, thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay, state any argument.
Your Honor, you've heard the sheriff's office's position. They're in charge of courtroom security. They presented basically their position that she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at a counsel table to question witnesses? How are we going to go about getting back and forth to the clerk, to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed, to be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole, with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy already identified, Deputy Lowen and Bulletin identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panel is located in front of defense counsel's table, would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally, just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, you're just address all concerns, which is the court's plan.
Got it. All right, thank you very much. Look, I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder. And there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than the defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder who is representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives were less prejudicial.
We've reached the top of the hour. We are hitting the pause button. You won't.
I'm sorry, I'm still on hold. Of course you are. No, they're not allowed. The jury's not allowed to see any kind of shackles or anything at all. So, yeah. So as soon as they come on, I'll mute myself. So what they'll probably do if she doesn't get to go up to the actual bench, they'll have headsets for her to listen. But I'd take the shock ankle. I wouldn't want to be shackled. I would definitely take the shock ankle thing. Yes, ma'am. Yay! Okay, that's kind of interesting. Okay, so if I was her, I would go for the shock thing because those ankle chains are heavy, they're uncomfortable, they're miserable. How much you want to bet day 2, if not day 1? She'll be asking for the other. She is dangerous. She has 4 counts of domestic violence. I'm not wondering if he didn't stab her in defense, but because he was a man, he was prosecuted. Just saying. Just saying. Yeah, no. Good to go. Finances are all there for my college. I got fully scholarshiped and all of that. So I didn't. What happened was that it showed a hold on my account, and I just kind of panicked a little bit because it showed the hold, and I found out that when you're a transfer student for the first semester, they put a hold on your account to make sure that you are not enrolled in 2 institutions at the same time. So all is well. So I'm happy. Me Too thinks she started every fight, most likely, but doesn't matter who started the fight. She's the one strangling and embedding metal into someone's leg. I'm like, really? Y'all. Oh, don't you hate those little itches? This little wooden, I have multiple of these. This is the only set I do not eat with, but these are fabulous for a lot of reasons. You can scratch and not mess up your hair. You can push buttons, do all kind of things. So, interesting. And this has gone on, what, a good hour and a half? Yeah, at least, I think. Let me see. What's their time frame on this? 2.5 hours, but she didn't go live until an hour. So it's been about an hour. Yeah, we're going to have Karen Reed at 12:45. I'll be live at Karen Reed. I think they go 1 o'clock our time, 2 o'clock their time. So I hope y'all join me. In the meantime, we wait. She is dangerous, y'all. She's dangerous. Thank you, Court TV Live, for your broadcasting this. Ooh, I don't know why they have to go into commercials. Come on, y'all. I'm ready to get going. So, I would love to see some psychological analysis on her. Real ones that, I'm not talking about commentary. I'm talking about the real thing. I know they do that. I wonder what she's been marked as. Let me go through in here. I'm not sure if he will. I think because of the uniqueness of this case, normally they don't. I heard a judge say, they're in charge of you. They make the decision. I have no skin in this game. But because she's pro se, because she's who she is and the crap that she's given, I would venture to say that the judge is most likely going to order the electronic or the ankle. Because she's going to have no. I don't think very many defendants I've seen in court during actual court actually have shackling.
There was virtually no alternative to a stun gun given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was a first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up in court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who is in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect. Thank you. All right, so now the court's going to grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the council's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, the only thing you have is your handcuffs.
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
Okay, so they will have the stun cuff on her.
The other item I have
Supreme Court.
on, yes, sir.
I think the
Get it off
sheriff's
her
office is
foot.
looking for clarification, I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back. If that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints. That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that.
Yes,
Yes,
also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with belly chains and all that. We can take those off.
In
If she
advance.
gets up here.
Yeah, I agree.
I'll be right back, y'all.
I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay, and for the purposes of trial, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. As identified by Sergeant Barnett, you're gonna have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to?
It is under your clothing, as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's gonna have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes,
Okay?
thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that, I saw the confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm going to give the same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you could do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand. And you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy? Or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I have spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom so that there will be a deputy for basically your disposal, be slated closer to you, so that if you have a document you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Yes,
Any other questions
Fran?
about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State your name, clarify.
No, Your Honor.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5, required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024. A representative from the Orange County Jail sent email to my judicial assistant, email provided in the order, all notebook IMS from the prior week, Monday through Sunday, for every issuance of the laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today.
So she only gets the computer Monday through Friday, 9 to 5.
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Yes, ma'am.
In regards to the status reports, you were just speaking about regarding them providing me with a laptop each day. What is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday. It was also mailed to you on, I believe, the 30th.
There was.
At the appropriate PO box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, and my concern was they're not stating what it was that I looked at for how long and
I don't know that they're going to record that information of the protocol, ma'am. It's just simply when it's checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we did discuss this.
All right, this Sarah Boone gets one answer.
Y'all. You out. Take your toy with you. Out. Come on. There you go. Come on. Get it out. There you go. Thank you. Oh my gosh. She is driving me back crazy today, y'all. I'm sorry you're seeing me getting up and down, but this kitten, she doesn't have any, well, she's too young to really have a reaction to catnip, but boy, she's acting like she's been in it. I feel bad for the judge when he asked if she has any other question. He already knows she does. Yeah. It's like, any more questions? Yeah. It's like, I think she'll be coming prepared. I think she'll come prepared. I think she's one of those that will be ready. She'll come prepared. Well, why is this doing this? Will it go bigger? Will it embiggen? Nope, it will not embiggen. That's what I did it, I think. Let me get that off. Y'all. I am somewhat concerned for trial. It's going to be interesting. Sensei, go lay down. Go play. Oh my gosh, that is so good. The human kind, the human catnip. Catnip for humans. Wonder what that would be. Oh, my neck. Y'all. Y'all. Okay, I might as well do it. Oh my God, y'all. We did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members-only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon-to-come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing. We have the emojis! Yay! Let's see if I can put them all up. Boink, 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 boink. Not in any particular order, but we have emojis. My fabulous mod boss helped me make some of them. We both made some of them. And so we have emojis. I love the Highlander. That's my favorite. My Highlander. And for those of you who can see my Highlander back there, that's Heidi the Highlander. Y'all named her. She seems to be the channel mascot. I have another Highlander right there and another one right there. Friend of mine decorated my office, and oh, wow, that cord fell. I'll have to fix it. So anyway, that's where we are. We got Holly the Highlander. So if you are a member, show your love by putting up some emojis. If you're not a member, please consider being one. Also, please subscribe. We appreciate subscriptions and liking. Just leave your DNA. I like that phrase. Leave your DNA. Oh, come on. These commercials feel like forever. It feels like forever, but it's a typical commercial break. I'm wondering if they're forcing her ex to continue paying what he was paying, be it alimony or child support. Child support, no. Alimony, if it was ordered, yes. I would think so, unless there's a clause in there that says unless she goes to jail or prison. Right now, she's innocent until proven guilty, so. Although that video of hers is pretty self-damning. I gotta be honest, I really haven't watched the whole video. I just saw a clip of the video. I hear she goes, shh, to him. Oh, that's going to creep me out if I see that. Oh my God. I already having bad dreams about the guy who came into our office after hours. And yes, they do provide the street clothes if she cannot get them on her own. I can show this. This is what I have right here next to me. I can't show the real thing, but I can show what holds the real thing. You know what holds this? Do you know what that holds? Yeah. And we had a guy come in the office one night at 9:30 while I was on my first ever members only live. And yeah, I'll just say it was creepy as hell. I could see an uprising in the jail with her getting all of the special perks. Yeah, I guess I need to pre-watch that so I can beep or try to beep it out. Oh, that's the wrong one. Or I could do this one. Not to trigger anybody who's been in that situation. Oh, for those of y'all who didn't see the other day, I went to a kind of like Goodwill. And look what I found, a vintage, $2. Vintage, very vintage, $2. Now I can do my own. I can do my own. Don't have to rely on the sound effects. But I, yeah, the good thing for me is that I can't hear. I read. What y'all don't realize is when I'm looking here or over here, I'm reading what's being said. I'm not necessarily hearing it. I know, isn't it nice? And I showed it, and Braxton has a vintage one with the the block and a law book, but his is from the early 1900s, and so is this one. I know it, and this is okay. From what I was told by the research and everything, and somebody I know in this that does antiques, yes, this type of wood, this style is definitely turn of the century of 1900s, not 2000s. When I talk about turn of century, I'm thinking the other. Does have a repair on it, as you can see right there, but great job repairing it. This type of gavel would have been used in a big courtroom. The gavels really were pertaining to the size of the room. He said this, I got to get this.
We did discuss the physical evidence, and I know that that was something pending in regards to the media being.
The physical evidence were set to review that here in court on September 3rd at 9 o'clock in the morning, and that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and defendant on September 3, 2024 at 9 a.m. at courtroom 12A, Orange County Courthouse, and at the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media?
Yes, ma'am. I've pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing. We can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th?
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problems. The Miami Herald decision, I don't know.
No. What they're going to do is have a time where she can come in and they both sides look at all the evidence. It's an evidentiary hearing. And the judge is not quite sure if he should or can or whatever actually have the media there, because the media does have a right when it's in the courtroom in that space in the courthouse. It's usually open to public. So, so the problem with that is the judge is not sure he wants the media to be in on this while they comb through and look at the evidence, because there may be some autopsy photos or the actual suitcase or other items that Well, the suitcase will be shown, but there may be images and stuff that pop up on screen that they need to make sure that is not shown to the public because of the respect for the decedent. I'm not a lawyer, but that's my understanding. Fran, I don't think so. I know, right, Fran? But that was not necessarily for the court itself, for the trial. It was just for the evidentiary hearing. That's where that is.
A citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank
And
you.
that will be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the state
evidence, the digital evidence only.
of the 2 USB drives from Mr. Lane.
Oh, no, ma'am, the USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections.
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well, ma'am.
She will view all the evidence on the 14th, and then she has until the 23rd to give written objection to any of the evidence and state her case as to why. Mm-hmm. So that's what they're discussing.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No.
Ma'am, is there anything else?
I do have this. I made a copy of it for you. This is the letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a word program, just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives and just, as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, well, you can give your letter to the deputy. We will file that in the court file. Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain Di Giovanni was returning on August the 12th from a vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on the media request, or prevent media from being at the September 3rd discovery viewing hearing.
One or the
Will
other.
address your concerns as identified in this letter, and have a representative from the jail, be it Captain DiGiovanni or someone else, here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded inspecting and testing and photographing, I believe that is my business only, and one bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence view, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay. I will see you all on August 14th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Barrios also send you a copy by way of the mail. It was already mailed. Okay, we're going to mail you a copy as well, ma'am. Today, I'm going to give this to the deputy and provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes, thank you. And then also the public defender's office, you said, would be meeting me downstairs?
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, David? No, Your Honor. Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail.
Thank you.
Okay, Sarah Boone, defendant, and she's a pro se defendant. She's represented.
Yo. Yo. This is insane. I know, right? Close. No, I'm just kidding. What do y'all think? What do you think? What's your humble opinions? They're doing it on the 14th. I think they have the 3rd in reserve. So I think the media hearings on the 14th of August, September 3rd, I think the judge went ahead and put it in the docket as a reserve, if I remember correctly. Let me look, because I write everything down. Or did on this one anyway. Okay, so the 14th is the meeting, is the actual evidentiary day. The 3rd of September is the actual evidentiary day. The 14th is set for the hearing concerning the media, and God knows what else she's going to throw at them. So the 14th is a hearing for the motion on the media being allowed to be in the courtroom for the 3rd. And the 3rd is when they're going to do the evidentiary, unless they've changed it, because that's how I wrote everything down the other day. We'll see. I know. Okay, guys, I'm going to run and grab lunch. I'm going to clean up my office because it's a hot mess and it's driving me crazy. And I just want to clean. And that's not a good place to be. So I'm going to let you go, but I want to thank all of you for joining, and for all you first timers. You guys are awesome. When does the actual trial start, Fern? October 7th, I believe. When is it? We've got so many dates flying around. Do you know, Ronnie? or I'll look it up. I ought to just leave this thing open. So the 3rd, or it's at the end of September, early October. Donald Adelson. Pre-trial. Okay. Pre-trial is on September 26th. And trial hopefully will start the 7th. And that is where we are. So hopefully the 7th of October, September 26th is pre-trial. October 3rd is evidentiary. And September 14th is the motion for the media to be present during the evidentiary. And I can't remember. I memorized all that. Oh my God, that's so awesome. Coffee's working. I won't remember it in 5 minutes. October 7th is the actual trial schedule date. We shall see. It may be moved depending on what shenanigans she throws at the court. Okay, guys, I bless you. I look forward to seeing you guys again at 12:30 my time, 12:45. We begin trial for Karen Reed. Motion hearing at 1. Come back and join me, please. I've enjoyed having all of you. Until later, we'll see you. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.